How many attorneys do we have here? Okay, and how many prosecutors? Wow, and let me guess who the rest of you are. Good, I'm glad we have a lot of criminal defense attorneys here. I'm also glad all the nurses are here in case my heart starts acting up. That I know you'll be able to make sure I get my flight. I'm really disappointed there aren't any prosecutors here because but for prosecutors' involvement in this issue in California, Colorado, and Virginia, Ron wouldn't have any states listed up there. This is just an issue that kind of languished and stayed hidden for a while until we, prosecutors in California, brought it to a head, brought it to the Attorney General, characterized the issues in a way that this gentleman's question was answered before it was asked. And so I travel around the country to different states that want to try to address this in just the way I'm going to talk about it today, and just the way it needs to be addressed, because the issues are not what they appear to be. They're pretty simple, and the question should be not why not, or not why, but why not? And it's simply another adjunct to what we already do. And for defense attorneys, let me turn the clock back 20 years ago. For those of you who were practicing 20 years ago, it was your job to challenge and undermine DNA evidence. And eventually that evolved, and there's still bases for challenge now, but most people embrace it as a truth-finding tool. And this is just another one of those tools, and someday in the near future, you'll want to use it in a case of your own to find out the truth of whose DNA or who the DNA belongs to in a case that you're handling. So I hope I'm going to answer all your questions in my talk, because I've been through this a number of times. But anyway, that's my name, that's my business card, if you'd like my business card. For the first time in recent history, a police chief has come to the forefront in Florida, a state that used to be very progressive and proactive about it. We've got a serial killer unsolved, very much like the Grim Sleeper, not the same magnitude. And this police chief is a very proactive guy, and he's out there beating the bushes as recently as this week, talking about familial DNA searching. And I can predict what's going on internally within the state entity that runs the database program. It's the same thing that we encountered in California 5 years ago, Colorado at the same time, and Virginia more recently. But only for some reason that doesn't make sense, unless and until things like this happen, and they're out there in the public domain, and for those of you who are journalists here, you can bring this to a head, as happened in Virginia, and cause the discussion to become more public, so that whatever the real issues are, they can either be addressed or not. And if they're addressed, then time to move forward. So here are some of the myths I want to talk about. There are too many false leads produced by this process. There's no software available to do it, or it's too expensive. Another one that's real pertinent to Pennsylvania, that you need explicit legislation to do it. And Ron made that point to this gentleman's question. I'll talk about that in great length. It doesn't work very well, or it doesn't succeed very often. That you need some sort of admissibility hearing to use it in court. And finally, probably the one that strikes the chord with most people, that this applies disproportionately to minorities, and it results in genetic surveillance. That sounds like a terrible term. It really does. And I'm going to talk about that a little bit too. So I think the first question we need to address is, does it work? Because why would we want to do something that's not going to work? So the answers are fairly obvious. Ron talked about the Grim Sleeper case. We actually had our second success recently, not the same kind of high-profile case as the Grim Sleeper case, but it's pretty high profile to this victim. or to this nurse in the St. Sart office that collected the evidence during the rape exam. So this guy was out there for a period of time, able to do whatever he wanted to do until he was arrested. One measure of whether things work in the scientific community is whether or not the process has been published. Well, the California Department of Justice and our Attorney General, now our governor, is the one who decided to do this unhesitatingly. Now the process has been published in a peer-reviewed journal. This is a validation article. I think it's one of the handouts here. So if you want to see whether the science is sound, I don't think anybody's really challenging the science. There are a number of different approaches. Colorado's got a software that I know Virginia has accepted and tinkered with, and Pete will talk about what they're doing. So it works. It works so well that our Attorney General has decided to double the funding available for it just this week because they're so impressed with the potential that it does. And who's going to value how well it must work before we're going to start using it and trying? I think what's interesting about in the LA Times article about the Attorney General doubling the resources is, if you read this quote accurately, the ACLU likes the safeguards that are built into it. They just want to see them codified. They want to see them put in part of our part of law. We did not even ever contemplate changing the law. And I'll talk about that a little bit. Never came up. So this fellow from the ACLU seems to like what we're doing. He just wants to see it enacted as law, so we can't ever change, for whatever that's worth. So it works, but how well? Because still, again, these are tight budget times. Our state's some in desperate financial straits, but somehow they're going to double the funding that's available for it. But then the next question is, for those of you who are in that same position, just like Virginia was recently, how well does it work? How compelling an argument can we make that we should be using it? Let me just describe the process. Familial searching requires special software. It's something that happens after a case is searched against the multi-million person national database and no match results. This is specialized software, and the software is asking a different question. The person that matches this isn't in the database. Is there a close relative in that database? And it's not that complicated to develop that kind of software. Close relative has a limited definition, a narrow definition. Father, son, you've already heard about, and both of our successes are father-son cases. The second one I showed you is the opposite. The father was in the database, the son was not. And those questions are a little bit more easily answered by the software. But in the software, when it asks that question, then it prioritizes them in the order that they're likely to be a close relative. And if you want to read more technical detail, read the validation article. So they're prioritized. A second set of testing is done. Familial DNA searching encompasses, it's a process that encompasses both of these. So yes, in the first part, there's a lot of leads. The second part is what narrows it down, in California's example, to either none in most of the cases or one in the two successes. I think that's what's critical to understand. California's two successes have only produced one lead in each instance. The second set of testing is what either confirms that there's a relative or refutes and says there's nobody here in this list of prioritized possible close relatives. So out of 16 instances, 2 leads have been produced, and they've been successful when they obtained a sample from the person that the focus was on. And you can hear how, when Ron talks about this, how exciting it is to have the lab call you up on a case that you've never been able to solve and said, is somebody in this family? It's real easy at that point, and I'll talk more about that later. But we're talking about how successful it's going to be, or it has been. Well, in order to do that, I think we need to compare that with the offender database in general. CODIS is what we use to describe it. This is from the FBI website. They measure success by counting how many times it matches a person or it matches another case. Okay? So that's their primary metric, the investigation aided category. So let's talk about that, because I think what's important to realize is CODIS is just the beginning of the process for holding people accountable. So the more important question is, how many of those CODIS investigations aided result in convictions? Not how many hits there are, but how many result in convictions. Well, I think generally speaking, what you may be surprised to learn is we only make these offender matches where it matches a person about 1 every 4 times. Yet you'll never hear anybody disparage CODIS, because that's more than we would have had we never done it in the first place. But the real question, I think, is, and CODIS also counts as part of their successes, these case-to-cases, but there's no measure of whether or not those case-to-case produce investigative leads that result in solving the cases. CODIS does not include familial searching or a related distant cousin of that partial match disclosure. Yet we've already shown you that familial searching can solve cases and lead to convictions. In reality, this is my revision. I think CODIS should contemplate counting familial searching as succeeding, because we've already shown that it succeeds. Yet on a national level, that hasn't been embraced yet, and only 3 out of 50 states have embraced familial DNA searching. In order to try to really compare apples to apples, I think it's important to say, well, how many of our offender hits result in convictions? There's no national tracking of that. I doubt there's anybody in Pennsylvania that can answer that question. What percentage of your offender hits result in convictions? We tried to do that several years ago in something called the Cold Hit Outcome Project. And what we learned was, out of the 27% offender hit rate, fewer than 50%, about half of them, lead to conviction. So in California, what we can tell you, at least as of a few years back, our conviction rate enhanced or produced by CODIS is about 13.5%. So the UK's done quite a bit more familial DNA searching, and I just put this slide up all there at once because the important line to look at is at the bottom. They've attained a 12% conviction rate from their familial search cases. And granted, it's a much smaller data set than the thousands of offender hits that we had in California. But it begins to tell you that if we do this more expansively, we may have the same kind of success rate that we have nationally or in California from CODIS. So then the question is, well, why aren't we doing it? And again, I still don't have the answers to that. Anecdotally, if you look at what we've done in California so far, 2 out of 16, we're all about in the same ballpark, the UK. So it may be close to what CODIS produces. It's going to happen on a much smaller scale because people don't have the funding. In California, it takes time to do all these things. It'll speed up with the doubling of the funding. But it can work pretty well. If you like CODIS, there's no reason why you shouldn't like familial searching. All we're trying to do is solve crimes. I haven't talked about some of the cons yet. I will. So here's the question. Can it be done? And this is really pertinent to Pennsylvania from a legal point of view. Well, the FBI has taken a position. Now, what you need to understand is the FBI controls the between-state activity, between and among state activity. The FBI merely facilitates this network of state databases. They don't own the data, the states own the data. So the first statement they make is, doesn't explicitly authorize it in 1994. Well, we weren't even talking about it in 1994, so that statement is not really helpful. It's not really very informative. So given the lack of explicit authorization, that's true. They don't conduct it. It's not explicitly authorized. But here's the key. Each state can do what they want. Otherwise, California wouldn't have been able to do it. Colorado wouldn't have been able to do it. Virginia wouldn't have been able to do it. But I think this statement deserves further investigation or further evaluation. Because once again, I'd like to think that people who are contemplating this are saying, well, how did California do it? You know, we're pretty liberal out there. I mean, we vote on how we're going to keep animals that we're going to eat someday. That kind of stuff gets on the ballot. So we're really sensitive about these things. So, and I can tell you, you know, that the bill that you have on the table, we have a process that lets people vote on things called the initiative process. And when we went to all felony arrestees in 2001, the people supported it 2-to-1. So an extremely liberal state like California likes finding the right people to commit violent crime. Who wouldn't? So, but here's the point. And I think this was a little bit buried in this generalist question. These are all technical terms that you will not see in any state's statutory authorization to construct a database to try to solve crimes. They're technical issues. Most of you probably, unless you're forensic people, don't even know what they mean, and I'm not going to talk about what they mean. The reason that's important is that these statutes simply authorize an activity with a purpose. They don't tell you how to do it, they just authorize you to do it. States are left to self-regulate. This is consistent with the FBI statement. You can do whatever you want within your state. It's when you want to do things between states or among states that the FBI needs to approve of that. And so the real question then becomes, well, if you're going to self-regulate, what are you losing by not being able to do this between state and among state activity? And the answer is not a heck of a lot, because as you would expect, 87% of your offender hits within CODIS happen in the state the crime occurred in. The guys in that state database where the crime occurred. So even without the FBI approving of this process, which would create huge logistical nightmares, you're not going to be missing much by not being able to engage in this process throughout the country. So I think it's important, and you can tell which states I've been as this list grows, to look at the legislation that exists nationally and in all these different states. The DNA Identification Act that was alluded to in that FBI position was that the database exists for law enforcement identification purposes. This is our California one for law enforcement identification analysis. This is the Virginia statute in the furtherance of an official investigation. This is from Illinois, identifying and assisting in the prosecution of. Arizona for law enforcement identification purposes. They all have the same concept in there. It's enact this database, who you're going to collect it from, when you're going to collect it, and this is why you're doing it. This is the whole purpose for it. Pennsylvania. We're all the same. I mean, we copy each other when we write laws just to be safe if one law suffices. So this is your existing database law. And it describes a purpose. And believe it or not, a lot of states are saying what the FBI is saying, which doesn't really address the question. Can you do it? Does your lawyers look at this all the time? For your defense attorneys, if you're going to look at a statute, you say, does it explicitly authorize it? Is it implicit? Does it preclude it? And if you get a prosecutor or defense attorney, they're always going to disagree, and then you have a judge decide who's right on these things. So, but this is the existing law. And let me just try to make the argument. This was a harder argument to make until Virginia and other states acknowledged that, yeah, it's within the parameters of existing laws. I was actually there in our legislature when we changed our law in 1988. And clearly there were restrictions, but they were restrictions on use. These were purpose-based restrictions. We couldn't use it for, give it to insurance companies or for employment purposes. But our statute always had criminal identification as its purpose. And so here are some of the possible outcomes of CODIS itself. Okay, CODIS can say, this is the guy whose sperm was in the dead 5-year-old boy. Pretty clear that identifies the person who killed that young man. But sometimes it identifies somebody who's there, and it gives a guy like Ron somebody to talk to that will end up leading to the actual person that committed the crime. CODIS doesn't care about that. It provides investigative leads, remember, from the CODIS website. There's something called mixtures that can produce a hit that leads to somebody else. CODIS doesn't distinguish. CODIS provides a matching service to provide information to an investigator to go out and try to solve a crime. And conceptually, are those investigative leads any different than what Ron described in the Grim Sleeper case? And they're not. That's why it was so easy in a liberal state like California, once you had the right people identifying the issues and characterizing it in the right way, for California to decide to do it. And by the way, there have been no legal challenges to it. It's very difficult to contemplate the form that a legal challenge could constitute to cause concern. What people have done is confused familial searching, which is the means, with criminal identification, which is the purpose. The purpose doesn't change. We just have found a new way to provide a means. And while familial searching is contemplated in the bill that's pending, I think is 775, strange things happen when you go to the legislature. Things change and you end up with something that doesn't resemble what you went in there hoping to get. And so while I understand the state police has requested that legislation, to me it's ill-advised because it's unnecessary, and in a state that doesn't seem to be able to pass a law that requires collection from all felony arrestees, it doesn't stand a snowball's chance in hell of passing. If you want to know, the 9th Federal Circuit in California is the most liberal federal appellate court in the country. It's reversed by the U.S. Supreme Court 97% of the time. Yet, in the context of a legal challenge, this is what they said about familial searching in terms of violating anybody's rights. So what's going on in other states? We've heard about the states that are doing it. What you need to remember is none of those states sought legislative help in doing this. So Maryland has a law that has I think it's about to expire, that prohibits it. D.C. has a law that explicitly prohibits it, and that means it's prohibited for defense theories too, by the way. Tennessee has introduced what seems to be a simple bill to authorize it. There's a bill in Pennsylvania seeking to authorize it, and there's a bill in Minnesota seeking to authorize it. So if they're not a legal challenge, then I guess you have to ask policy. And you know what? This is the heart of the matter. Are the policy issues, public policy issues, for or against it, that we should adopt it? And you heard Ron's. And it's just too easy to say, well, we're going to solve crime. Okay? That's not good enough for anybody. So we should try to find out what's wrong with it. So this is probably the most inflammatory part of the whole debate. And I hope to convince you when we describe the process, and we have 2 cases that actually give you the answer already. Is this race-based genetic surveillance? I'm not sure what people mean by genetic surveillance, but it sounds terrible. And here are some of the allegations that are out there. Genetic surveillance of millions of innocent family members. It's disproportionate because what do we know about our offender database? It mirrors our prison population, and we know minorities are overrepresented with respect to the community as a whole. Then those people, those innocent family members, are identified, accused, or suspected. Well, Ron talked about the grim sleeper a little bit. I hope you're asking yourself, how could that be? And I'm going to talk about both of our cases to actually refute that point. So we've had 16 searches in California to date. Well over 1 million offender profiles were there as possibilities at the beginning of the search. So that's 16 million opportunities to do all the things in the left-hand side, all those terrible things in the left-hand side. So what did we do? Let's see if those predictions came true. Each time we end up with a candidate list of about 150 or more samples that we do that lineage testing, that second round of testing. Remember, they're ranked in order of likelihood of close relationship. They're just numbers. We don't care who they are. Why? Because a cop doesn't care who it's not. He wants to know who it is. They're anonymized at that point. The police are not involved in that part of the process. Why tell the police, here's 150 names, it may not be anybody on the list. When you say, I have a test I could do that can narrow it down to one or none. And that's exactly what's happened. In each of our 2 successes, we've produced one concordant result with that lineage testing. YSTR is the male lineage testing that's done in cases. One name in each instance. And just so you can understand, whoever asked that question or Ron about the possibilities, dads and sons are going to have to share half of their DNA with each other. Brothers don't. So when you see half between the offender and the evidence profile, it's almost certainly not a brother. So you say, okay, it's a father-son. In the Grim Sleeper case, you say, well, wait a minute. 1988, I can't remember how old the son was. He was 3 years old then. I'm just making that up. It's got to be the father. The Santa Cruz case, the second one, was just the opposite. You have a surviving rape victim. She said it was a young guy. The father was in the database. So that happens by integrating the information that the investigators already know. And it could be as simple as that. It's the father, it's the son, with any of the other geographic information. So are we exposing millions of innocent family members disproportionately to genetic surveillance? It's hard to argue with the truth of what we've seen in California with millions of opportunities to do that. It just hasn't happened. And it's highly unlikely to happen. We have the largest database in the country. But just to make this point a different way, are all those millions of innocent family members, I mean, Ron made the point, you don't even have to talk to the son or the father. It's at a terminal that you could see all this and say, let's look at the father, let's look at the son. But here's how I just wanted to demonstrate this. Just imagine this is the database, and you just say, yeah, but I can see their faces and stuff. Well, it's really like that, because you know what? We don't care what they look like. We don't care how tall they are. We don't care whether they're dead or alive. At this point, until, here's the list, the candidate list, the lineage testing. Only when the lineage testing addresses that list, this is what happened in the Grim Sleeper case. Looking at the father-son info and the dates of the crimes, it's got to be him. Now, I know people have voiced objections about using what's called abandoned DNA, but most states, appellate cases, case law, resoundingly supportive of using that. That's what was used in the second case as well, abandoned DNA. Police officers know how to conduct their investigation within the confines of the Fourth Amendment. It'd be silly, after everything that would be done in these cases, to risk violating the Fourth Amendment. But even that, there'd probably some recourse. So, but here's why what I just showed you is the only way to do it. The police don't care about the list. It's really cost effective, okay? In California, we end up typing about 150 to 180 of these offender samples. That costs about $40 a piece to do. Compare the cost of that versus giving Ron a list of 150 names and saying, you know, maybe somebody on this list, maybe it's not. I don't know. Go ahead and think about how much time it will cost to do all that. The offender database in Pennsylvania is about 1/6 the size of California's database, so that actual testing cost is going to be a lot smaller, much more cost effective. But doing it this way, it was very clear. It would address all those stories about race-based genetic surveillance. Why? Because I just showed you how it works. You end up with one name, and then you approach collecting a sample from that person's close relative that you've identified, usually at a computer terminal, to find a legal way to get a sample from him. And then when that's confirmed by testing, go out and directly obtain a sample from him. It completely disposes of that question about race-based genetic surveillance. But here's the problem. How can we let our legal system, which is supposed to value truth, the truth-seeking part of it, by having a tool that we're hung up about, that both sides can use, because we can't have a tool, law enforcement can't have one that the defense can't have. So it has the possibility of withholding real investigative leads. It could help convict the innocent in a given case. Having it not available to the post-conviction testing process bothers me a little bit, and I'll show you why in a minute. And it could lead to convictions that were thought to be sound being reversed in hindsight once it's developed. So it's kind of the elephant in the room. It just can't be ignored for the potential. So why in the post-conviction testing process? Anybody here involved in that process? Any of the defense attorneys? Well, Pete is, I mean, because they provide services to the entire state. If I were seeking post-conviction testing, which for those of you who are not familiar with the legal system, states have statutes that afford people who have been convicted the right to seek this under certain conditions. So, and occasionally it identifies people who are in fact innocent. Occasionally it identifies people that deserve new trials. So it has a valid, well-established place in our legal system, but it's missing this tool. And let me explain why that is and give you a case example. If I were seeking it in court, I would be afforded the opportunity to test the evidence. And sometimes if it doesn't match the defendant, that alone exonerates him. Pretty easy to understand, the rape of a young child or even a victim, a single victim. But sometimes the fact that it doesn't match somebody alone doesn't exonerate him. And that profile has to be searched against the offender database. And only when it matches a murderer in that area or a rapist in that area is that enough to exonerate him. But sometimes even that doesn't succeed. Remember, CODIS only produces matches 1 out of 4 times. So sometimes that alone. So you have people convicted with unidentified evidence, and we have this tool that maybe 1 out of 12 or 1 out of 8 times is going to identify somebody that may shed some light on whether or not they're innocent. So this is a tool that remains unavailable to them unless you're in the 3 states that we talked about. And in states like Arizona and Virginia, where they had multi-million-dollar federal grants to do post-conviction testing, someday soon we'll see familial searching in the right case exonerate somebody. We just can't have a tool that only one side has access to. So following up on that point, a couple of months ago, I was invited to talk at the Northwestern Center for Wrongful Conviction. Mitch Morrissey, the Denver DA, he and I have been very proactive in this issue, and we talked about this. And it was very well received by them. And it was very well received by them. And for those of you who think you're against it, I want you to listen to this case and tell me how you feel about it afterwards. Juan Rivera was convicted. Oops. He's actually been convicted 3 times. He was convicted the first 2 times of a murder of a young girl. And those convictions were reversed for different reasons, different legal reasons. So between the second and third time of his conviction, someone finally got around to doing DNA on the sperm. He was convicted based on a confession that he made. And we already know that sometimes, look, I was a prosecutor for 33 years. This was a bitter pill for me to swallow. Sometimes people confess to stuff they didn't do. I don't get it. I had a hard time getting my kids to admit to what they did do, so, but it's true. You can't argue with what we've seen. So 2 times he was convicted based on his confession that contained facts only the real killer would know. And between the second and third time, let me get this up there. This was an 11-year-old girl. She, in those 2 trials, she had sperm in her vagina. That's kind of unusual for an 11-year-old girl. Between the second and third trial, they were finally able to get around to doing DNA, and it wasn't his DNA. Now, for the life of me, I don't understand how you could convict somebody for killing an 11-year-old girl that had somebody else's DNA, and your confession never kind of explained that either. But that's what happened. He was convicted 3 times. The third time, in spite of this DNA result, clearly not him, searched against the national database, didn't match anybody. But that's where the case stood. And so for those of you who, are there any people that think, for instance, familial DNA searching is a bad idea? Because if there were, I'd say, well, do you think he should get it? Because we can't be selective about who gets it. It should be done fairly and proportionally. And I'm all for having familial DNA done to help this guy out. I mean, it may match his brother, and then that ties him in. He wasn't going to admit that he and his brother were there. I don't know, but I mean, the truth is the truth. There's a truth-seeking tool out there, and Illinois is looking at trying to implement this over the ACLU's objection. I mean, if the ACLU had their way, Juan Rivera would never get a shot at this. That's just kind of hard to understand, how you could have principles that would obstruct somebody's attempt to be exonerated if that's what they deserve. Because this is really just a tool to try to help people get what they deserve, whatever that is. So, so let me just briefly explain the California approach. We're going to have a lot of time for questions. So after I retired, we started this process with the state just before I retired. And so after I retired, they hired me for a year to work with them on the protocol. And it was pretty easy to do. Understanding all of these issues were pretty easy to address and understand. The major part of the time was just developing the software that resulted in that article that's one of your handouts there. They really worked that over, and for those of you who have questions about it, you ought to just read it over. If you're not technically oriented, don't, but it's all right there. So recognizing this was announced by the Attorney General in April of '08, we were having a statewide cold case conference, and he announced it, and we didn't have the protocol, we didn't have the software, but it was huge because it was a question of going public with it. And so the real questions were, how do we control it? How do we ensure deserving cases? There's a little PR in there in the sense that we're only doing it for important cases, but you must ask for the second success, well, how did that square with it? It really doesn't, because you know what? Every unsolved case is pretty important, especially to the people who are victimized, but to the public as well, because of what we know about recidivism. So everything's in writing, the case description, all investigative leads have been exhausted, and that's pretty easy to, because otherwise they'd be still investigating it. An important part of it that I know we all have, California, Colorado, and Virginia, the prosecutors have to be involved in this. There has to be an understanding that if this succeeds, the case is prosecutable. Now, it's hard to commit to that entirely until you know who you end up with. Obviously, if you end up identifying somebody who's dead, you're not going to prosecute it. So it's as best can be done under the circumstances. And it's all in writing. This is all written out. In California, we have it's not a requirement, but that 15 loci, those are 15 separate data points that we have. And the reason that's important is that with a database the size of California, the software will produce a much shorter list the more data points you have in the evidence profile. So that's why for California that was pretty imperative, and you can see in the validation article how that worked out. And the other part of it is that lineage testing that gets talked about, the second part of the familial DNA searching process, that has to be done on the evidence before the case is even submitted, before the agreement's reached, because the state doesn't want to have to do that. They will end up doing that on the offender sample. So, and then the process kicks in. Now it takes time because until the latest announcement of doubling the funding for this, it just took a long time. There's a review committee that I was a part of for the first year. So the first step, just imagine it's like a slot machine in Las Vegas or Atlantic City. You push the button and you end up with a list, maybe 180 people, and the most likely close relative, father, son, brother, brother, is almost certainly going to be on that list somewhere. Okay? It's entirely possible that the person that's most likely to be closely related isn't on the list. It's highly unlikely. That research, the validation paper that I keep alluding to, kind of describes that. But what I think is interesting and reassuring is we've had 2 successes in California. The Grim Sleeper was number 3 on the list. So that means this is just by, remember, we have well over 1 million profiles. So the more profiles you have of unrelated people, the more you increase the possibility that there are people who are not related to you but resemble you just by, it's like buying 1,000 lottery tickets versus 1. So that's why the lineage testing is done on everybody on that list simultaneously, because you never know where the person is going to be if they're even on there. Interestingly, the second case that I talked about that just occurred a couple of months ago, the close relative was number 1. Okay, so it's pretty reassuring that this process is working really well. It's not an argument for just doing the top 5 or anything. That would be silly to do that. I like the way Ron described it, you've cast a wider net. And you're trying to capture people who are close relatives the way we've defined them. But they're not necessarily the biggest fish in the net or the smallest fish in the net. The research shows that if there's a close relative, father, son, brother, brother, full sibling, they're almost certainly going to be in the net. So you have to expose them all to that second round of testing to see if you really got that trophy trout that's got the prize number in his mouth. So they're prioritized. The lineage testing is performed. If that lineage testing confirms close relatedness, only then is that information disclosed to law enforcement for reasons that I described. If that lineage testing doesn't confirm it, the familial search investigative process has ended. It hasn't produced a lead. And here's what's interesting. The Grim Sleeper actually provides some insight into how well it works. Because what Ron, and you need to add this to the next time you give this talk, the Grim Sleeper case was actually the first case that we did familial searching on in California, and it didn't produce any investigative leads. And you probably say, oh, it didn't work, right? It didn't, how's that possible? You guys must have screwed up. Well, actually not at all. The son wasn't in there then. So it worked really well. The candidate list and the lineage testing, nothing concordant, no investigative leads produced. We have a provision that a case can be redone within a year. It was redone a year later, and what happened in that ensuing year? The son got convicted, was required by law. It was a real cheap felony, but our voters supported collecting from people in that category. When it was done the second time, the son was number 3 on that list. The lineage testing said father, son, age of the dates of the crimes had to be the father, and the rest is history. So, but here's how simple the investigations can be and will be. It provides an investigative lead. It's somebody in the family. If you're from a city like Pittsburgh and they point you to a certain family, if it's a investigator like Ron, he's going to know right away. He's not going to have to hit the computer to know which one is probably the likely person in that family. But so the family structure is the first order of investigation, looking at people's criminal history. Anyone in that family who was in custody at the time of the crime obviously couldn't have committed the crime. Anyone in that family who was dead at the time of the crime. So it's a process of elimination from a very small world of a population group. And then using what police have gotten very adept at, using abandoned DNA. The second case from Santa Cruz is exactly what they did. I don't know the details, but they got stuff from the garbage. It's perfectly permissible legal practice to do that under appropriate conditions. So we've already talked about this. So here's where I think it gets really simple, but again, I'm disappointed there are no prosecutors here because they're key to this, okay? They're lawyers, they understand issues, and if this succeeds, they're going to get these cases. I'm also disappointed that law enforcement hasn't been more vocal, other than the Daytona Beach police chief. This is not just a CODIS issue. It's not just a database issue. That's where it's buried in most states. It's all vested parties, and that includes defense attorneys. Select or design the software, develop the investigative protocol, but I've already shared with you the investigative protocol is really simple. It's more understanding the process and what it takes to submit a case, educate prosecutors, implement the tool, and follow the leads if there are any. This is just an enhancement to CODIS. And from what I've showed you, it has the possibility or the potential to enhance CODIS significantly. It's also pretty inevitable. California, Colorado, Virginia already. Illinois is pushing it. They have the apparent support of Northwestern as a member of the Innocence Network. We have these large post-conviction testing programs in one state that's already doing it, in Arizona that may. But all we're doing is tapping more of the potential for CODIS, the billions of dollars that have been spent establishing this national database, collecting all these samples, continuing to expand them. But here's the real payback, and we should already know this. If we don't do it, people are going to lose their lives. Just like anything else. If you don't use CODIS, you're going to jeopardize innocent victims. You're going to facilitate future crime. There's no question about it. We've already proved it. That's why it's so popular to use the database to try to solve these crimes. And so one of the Virginia prosecutors has been really supportive of this. When this fellow they were calling the East Coast rapist was finally arrested, suggested that the arrest could have come earlier had Connecticut, which doesn't do familial DNA searching, do them. It's just obvious that not only can we solve old crimes, we can prevent future crimes. That's the mission of CODIS. This is just an enhancement of CODIS. That's all I have. I hope I have a lot of questions.
Do you want to step up?
Sure, I can step up. Because this was our case, Paul Ebert is one of our prosecutors. I love Paul to death, but he's wrong. Because now what we know, that particular East Coast rapist guy, his conviction was in Maryland. And as we know now, if we would have searched him, we wouldn't have found him because we wouldn't have been able to look in Maryland because Maryland's got a law against it. So one of the things we have to be careful of is this kind of thing, to hype it one way or the other, we got to get it straight. And I'll go into great detail about why national searching is problematic unless you want to. It's not that it can't be done, but there are things you got to, hoops would have to jump through to be able to do it. But
so the relatives in the Maryland database?
Yeah.
Okay. Yeah, that was never
Which is
clear.
one of the problems you have to remember. And the relative is a convicted felon, but he's in the Maryland database. So no matter who would have done it, we wouldn't have found him because Maryland wouldn't let you search in it.
So you can't trust anything you read in the newspapers anyway. Any questions?
That was Pete Marone, who's an afternoon speaker, for those of you not in the know.
That was good. Yeah, no, I'm glad.
I would just like to know, quite honestly, I don't have any problem with the California protocol, okay? But as a defense attorney, I would like to know, do you provide documentation in discovery with regard to who, what the protocol was in a particular case, document chain of custody, and also document the software, because you can be doing a lot of this, and there are computer people in the audience who know more about this than I do. You can be documenting what you are doing electronically by having these printouts of the addresses that you're going through in these electronic searches, and also in generating those lists. Do you provide that information? Because quite honestly, if you were providing that information and I could look at it, I would say, hey, try to get a plea out of this guy. Do you know what I mean?
Yeah, no. Remember, I'm retired, so I can't necessarily answer that question, but I'll just try to revert back 3.5 years to when I used to work. See, the chain of custody of what? Remember, the evidence was typed usually by the submitting agency's lab. So the chain of custody, that's over there. Yep, you get that because that's part of the proof that's going to be used in the case. This is very much like a cold hit case where the computer does all this stuff. Then you go out and get a new sample from the person, and the proof that's used in court is the sample that's collected by the investigator with a search warrant after the abandoned DNA was collected. So it's not necessarily relevant because the proof is not that he's related to somebody in the database. The proof is that he matches the evidence at the crime scene. So I'm not sure how you'd have to couch that in the context of a legal issue to have that discovery discussion.
The legal issue is disclosure. That's the legal issue. And as a diligent defense attorney, you want to make sure that all of the procedures have been adhered to faithfully. Number one, you want to know what the procedures are. Sure. You want to make sure that there's chain of custody of the particular samples. You want to be sure that other sorts of factors have been eliminated. You also want to make sure that there's integrity of the electronic database, that this indeed is, as it says, going, blindly to an analyst by a number with, you want that kind of documentation before, or at least I do, before I'm going to accept this. And I want that kind of documentation to be able to make a challenge in court if I have to.
But see, I'm glad you finished on that point. And I would say, well, you have to tell me the legal issue that you want to raise the challenge under, so we can have that discussion and then give you the
Identity. That's the legal issue that I want.
and honestly, I think you'd lose that. But because, as I said, Ron's going to arrest him with a search warrant, so you can challenge the sufficiency of the search warrant. So it's based on the abandoned DNA typing.
Well, I just want to confirm that. No one made a suppression motion in that case.
Well, they can suppress on the abandoned DNA. They can suppress.
They can make a motion to suppress on several grounds.
No, absolutely.
Okay.
Well, you will. I mean, you have to. This is a capital case, so absolutely.
Thank you.
Yeah.
I actually have two questions. The first one is just a simple technical question. Can you explain what
Jay?
you... Yes.
I recognize your picture.
I haven't aged that much, I guess. The first one is a technical question, and that's when you say that you have to test 150 samples, I just wanted to get a sense of what that exactly means, because it seems very inefficient to to have to test that many samples. Was that the list of 150 people?
We call it a candidate list,
okay.
and it'll vary, but if you've read the validation paper,
I'll have to look at that.
It's
okay.
scientifically determined by, let me just explain the validation. How many of you are scientists? Okay. Oh, good. Okay. So DOJ took real and constituted family members and dumped them among the 1 million+ profiles in our database, having developed the software. And they said, what do we have to do to find the father, son, brother, brother? And that's how I've cut through months of work, but that's how, in a database that size, with a great degree of confidence, you'll end up with a candidate list of 180, 150 people. And perform the lineage testing, almost always YSTR testing on that candidate list.
Do you have to do extra work for that, or do you just tell the computer to check the YSTR?
Oh, no, you have to, and this is all computerized, but now you've got a repository of 1.5 million now samples, and you have to find those samples and do the typing, the YSTR typing on that.
Okay, maybe
that's additional laboratory testing.
Like actual wet lab testing?
Yes.
Okay, so you have to go back to the sample. So the YSTR is not loaded into the database it's not available electronically. It has to be produced.
Absolutely, yeah.
Okay, so that's why it's so expensive. That's why I couldn't figure out exactly
right.
what
Some
you're
states, Missouri's doing their whole database in WISE. I don't.
Okay. And I just really briefly, I know that we're low on time, but I just wanted to give a little bit of, as a social scientist, I wanted to explain the genetic surveillance issue in a way that hopefully people will understand it a little bit better. We all know that familial searching is not a racist technology. I think that's not the right issue. The issue is that many people would argue that the criminal justice system has racial elements, and it's unfair to African Americans, Hispanics, people who don't have resources, and that when those people are picked up and prosecuted and convicted at a higher rate, you create a higher rate of, or a larger number of people in the database who are minority. And the idea is that if you're starting to use familial searching, then it actually creates a disproportionate burden on that community, and that you're just perpetuating the racial inequities in the system.
What's talk about it in terms of what we actually did. Is the burden
No,
They
it's
didn't talk to
not
the
at the
son. They
DNA
didn't-
level. It's not at the DNA level. It's at
It's
a
a
much
psyche-
lower level.
is it a psychic
No, it's
burden
at a
or-
much lower level of the criminal justice system. If you're African American, in many places you're more likely to be stopped by a police officer.
But you see how easy it is to say, and look,
I'm only explaining it. I'm only
race is a
explaining it,
lightning
yeah.
rod. No, but I mean,
But I
you're-
was explaining it in a way that people
but
could
it sounds like
understand
you
a little bit
believe in
better.
it. Look, race is a lightning rod. I mean, that's such a terrible thing to inject in it, and that's why I said, what's the burden? And talk about reality. There's no burden. Okay, if that's true, we need to shut down CODIS, right? The same argument can be made about CODIS, right? I mean, it's right. Or what about the prison system? Let's just shut down the prisons and free everybody because it's that burden. But what you don't talk about is whether it's deserved. And in this case, is it right to use abandoned DNA after you've sat at a computer terminal and collect some evidence that confirms who committed a crime? You don't talk to anybody. You don't roust anybody. No, come on, that's explosive stuff, and that's why I'm happy you brought it up now, because there is no burden. The burden is deserved, as we've shown already. There's no burden, and it's deserved. It ends up where it's supposed to end up.
Well, the burden is not deserved if the system is selectively prosecutorial in the beginning.
But how's that happen in these cases? How did that really happen?
But they're in the database.
It didn't. Okay.
If the police are able to get convictions from the individuals that are already incarcerated and in the system, wouldn't that free up the police's ability and time to go after the cases that are a lot more difficult for people who aren't consistently in and out of jail?
Well, you already answered that. Yeah, of course. I mean, don't we want to get the right person? This is right where we were 20 years ago, where defense attorneys were resisting it because it was going to convict the right person. I know that's your job, but that's the reality. I'm in a time warp. I need to find my suits from 20 years ago because that's what's going on.
Suppose that I haven't heard you mention any female offenders or female suspects.
Sure.
If I were the sister or the half-sister or the aunt of someone in the database, you know more about the biochemistry of this testing. Would it have profiled me? Would it have kicked my name up?
You will show up on the candidate list if you're likely to. But remember, the software will only produce a candidate list that has close relatives the way I've defined it. So aunt, half-sister. The genetics are much less comparable, so they're not likely to show up there. And there is a female component to the lineage testing, mitochondrial DNA testing, that can be done. We don't often mention it because it's so unlikely that there'll be a female.
But do you test across that gender mitochondrial factor, or do you assume that it's a male perpetrator?
In what sample? I mean, the DNA typing, the evidence typing, there is a gender component to it, so you'll know with the evidence.
So you're looking for a male perpetrator.
No, you're looking for whatever the evidence draws you to. I'm not sure.
Well, there are a number of different profiling factors, one of which is race, but another of which is gender. If I were a male, I would be, and I don't know, maybe the whole, the reason there are more men in jail in part is because you're looking for men. But women commit crimes too.
Sure. See, that's why I think we have to focus either, are we talking about the offender candidate list or the evidence? The evidence is typed using a gender component to it. I don't know if anybody's got any data about how many forensic unknowns in the database are from females, but it's pretty small. So with that information, maybe this lady has an answer to that.
I don't know about the US, but I believe, and I might be wrong, but I do believe that I think in England there was and they do a different kind of, maybe a different format of testing. But there was a male who was found through his sister who was on the database.
That's true. We share the same last name, but a different spelling. His name Craig Harmon, if
Right.
you want to Google that. So that may answer your question if it's Harman.
So I don't know about the US, but I do know in other searches,
Sure.
women have led to males being convicted.
Well, she showed up on the candidate list, and interesting, I didn't mention this, but for some reason the UK doesn't favor this lineage testing. Their cops don't mind going talking to 100 people on the candidate list. Maybe they're a little more civilized there, I'm not sure. But nobody's raised the genetic surveillance there. That, you know, if there's a validity to that argument, maybe that's it. You can't talk to people like that because they're on the list. But again, cops know how to respect the Fourth Amendment on this issue.
So,
We have the microphone
Yeah.
here.
Oh, Mark.
hi. So just more of a comment. I think the YSTR confirmation for the male lineage is a good start. YSTRs have an identification power of about 1,000-fold. I would think that going forward, as we're seeing, I think there are like 10 new STR autosomal panels for the other 220 chromosomes that have been introduced in the last few years. Given the sort of familial relationships you're looking for, you actually would get a lot more power, about 1 million-fold in a parent-child, by testing another 15 autosomal markers. That would be gender unbiased, and that would give you about 1 trillion-fold identification information. So if you're going through all the trouble of pulling out hundreds of samples on each search, an interesting scientific approach that might yield slam-dunk information and not need any list at all would be to do additional testing with, say, 15 additional ordinary STR loci.
Sure, and you know, that's the scientific approach, and the problem is you've already added a whole line of work to and the line of work that the California validation paper has addressed has given you 2 people that were number 1 and number 3. So what Mark's point is, you could have nobody else on, or no list, and that's true. The more data you have, the more you can eliminate and narrow it. But I think from a cost-effective point of view, if you look at what happened after somebody says, look at this family at the computer terminal, you're not spending an awful lot of time following up on these cases in a database that's bigger than any other states.
One last question, because I want to make sure you guys get a break.
Yeah, you had a slide there that said, that represented a percentage that you wouldn't lose much in the inability to do national familial DNA testing if you do it at the state level. Are there also technical reasons that support that maybe a national search would not be favorable compared to a statewide search? Are there technical reasons why it might be more efficient to do it at a statewide level?
Pete, you going to talk about that this second? Yeah, I think it's logistically challenging. It'd be like the United Nations or worse. So, but no, I think the logistics of it are really daunting, and Pete's going to talk about that more.
Mr. Harmon, thank you very much for coming in.